9 weeks of trial in the Karen Reed case, 75 total witnesses, 5 days of jury deliberation. And on July 1st, the jury came back and said that they were hopelessly deadlocked. They could not reach a verdict or verdicts. Karen Reed was charged with 3 counts. Count 1 was elevated and added later by grand jury, but count 1 was that second-degree intentional homicide. Count 2 was the operating a vehicle while intoxicated or operating under the influence, with all of those added subparts, all of those lesser included crimes. And count 3 was the leaving the scene of an accident causing death. Those were the 3 counts. The jury could come back on all, on some, on none. The judge swiftly declared a mistrial. It was very confusing to me at the time. It remains confusing to me that the judge did not poll the jury. Have I ever seen a judge do that? No. I've never seen the judge in a undetermined verdict, in a hung jury. I've never seen the judge not poll the jury individually. And you've seen this. You've watched trials with me. You've seen this. And when we've seen this, we've seen even with a guilty verdict, do you want to poll the jury? Yes. And they go through the jurors. Juror number 1, is this your verdict? Yes. Juror number 2, is this your verdict? Yes. And they go down the row. I've seen cases where they've gone down the row and a juror's been like, no, that's not my verdict. And it's like, you can hear the record scratch in the courtroom and everybody goes, wait, what? I've seen juries be polled and have to go back to deliberate because one juror is like, that's not what I agreed to. But I have never seen a undetermined jury not be polled, ever. And the attorneys didn't ask for it in this case, but the judge very swiftly read the note and declared a mistrial. And it's like, once that mistrial is declared, this is all going to be hard to undo. But where are we at now? Well, Monday morning, a week after this jury was undecided and the court declared a mistrial, the defense filed a motion saying immediately the jurors started reaching out to them and that those jurors indicated that they did have some verdicts, just not all verdicts. Can a jury come back with a split verdict? Yeah, they can. They can come back with a verdict on count 1 and count 3 and no verdict on count 2. They could have come back with a verdict on count 2 and hung as to the lesser included. There's a lot of options that could have happened here, but this is going to be difficult to unwind. With everything we've seen from the defense motion, it's clear that one juror reached out directly to Alan Jackson and said, no, we were unanimous that Karen Reed was not guilty on count 1 and count 3. That's the second-degree murder and the leaving the scene of an accident causing death, and that they were hung, and it seems from later discussion, evenly divided, or at the end, 8-4, that they were stuck on count 2. Remember, count 2 has the DUI, but also all of the lesser includeds. And some of those lesser included that chain of event language. So if the jury was looking at, did this cause the chain of events, then I can understand where in those lesser includeds they might have gotten stuck in the weeds, where some people are like, yes, and some people were like, no. The judge never polled the jury, which is why the defense is now making a motion to dismiss count 1 and 3, saying that Karen Reed cannot be retried on those due to double jeopardy. There's also 2 other jurors that are brought up in an affidavit by Yannetti and in the motion, but those jurors did not speak to the attorneys directly. Those jurors spoke to other individuals directly, and then those other individuals spoke to their friends, and then those friends spoke to Yannetti. So when we get to the other 2 jurors, those jurors did not seek out the attorneys directly. They were speaking to others, and they weren't speaking to the people that told the lawyers. They spoke to intermediaries. Those intermediaries spoke to third parties. Those third parties spoke to Yannetti. And that gets a little bit more messy when we're looking at, is this really what the jurors said? Is this what they intended? A juror reaching out directly to the attorney is much more consequential to me than jurors telling their friends, friends telling a friend, and then that person telling an attorney. That becomes a difficult game of telephone, but I think there is a big issue here. The legal issue is also going to be, can this be undone? Can it be inquired about later? Is inquiring about the jury's vote in the jury room when they didn't put it on the verdict form, is that inquiring about the jury deliberations, which the court cannot by law do? The court cannot inquire about the deliberative process? Or is this aside from that, where you can ask about the vote and you can ask about the jury and poll them? I think there is going to be some fighting over whether or not the jury can be asked about this. But I wonder if more jurors come forward, if this will become more clear. And I wonder if now that this has made the news and now that this is publicly known, if more jurors will come forward. I mean, what we've seemed to hear from a Zoom call from a friend to a friend is that the jurors are all in a group text. And so I'm sure they are discussing this. Could it be that the jury initially said, yeah, we're all agreed, and never came back to those counts? And that's why they didn't put anything on the verdict form. There's a lot of possibilities here, but it's going to be real sticky to ask about those possibilities without getting into the nature and discussions that happened in the jury room, which the court cannot inquire into. It's why it was a little clearer in Murdaugh. They were asking about whether or not a third party had spoken to the juror, not what the jurors decided amongst themselves. Starting to talk about what the jurors are deciding amongst themselves is a legally difficult thing. And can I see this going up on appeal? Yeah. Is that more likely what will probably happen here? Yeah. At this point, I think the appellate court is ultimately going to have to decide whether this jury can be polled. What's the practical result of that? If the judge denies the motion to dismiss, if the judge denies any further inquiry, then that motion will be appealed, and the appellate court can review the existing case law and can narrow out an exception or can say no. But while that's up on appeal, I think that they can't go to trial again, because if Karen Read is entitled to an acquittal on 2 of the counts, you cannot retry her on those counts. And I think it will stall this case until that appeal comes back. And I think if this needs to go up on appeal, that's what should happen. What's going to happen in the meantime? A whole lot, because we're already seeing Proctor being relieved from duty and now being relieved without pay. We know that there's an ongoing federal investigation. So what happens next? We're going to have to wait and see. This is not going to be easily decided. And though it feels in the guts like it should be clear cut, right? Like if the jury truly decided this, it's a miscarriage of justice for her not to get that acquittal, if that's what they decided. If that's not what they decided, then everything goes forward like normal. But don't we have to know that? And knowing that is going to be difficult. How much legal research is needed on this? Lots of legal research. For deep dives into the stories that I covered here, you can find them on my YouTube channel at The Emily D. Baker and The Emily Show podcast. I stream every Tuesday and Thursday. The podcast goes live on Wednesdays. And if you want to stay in the loop with everything I'm doing, receive the fastest notifications out there, and get more Law Nerd community, join me at lawnerdapp.com, our free app for iOS and Android.